Assalamualaikum warahmatullahi wabarakatuh. My name is Aziemah binti Rosle, and I'm going to start with the introduction. Relevancy is a fundamental concept that runs throughout the Evidence Act 1950. It determines whether a particular fact may be admitted as evidence in court. Section 7 of EA 1950 provides the statutory basis for relevancy. Under this section, facts are relevant only if they show the occasion, cause, or effect of the facts in issue, constitute the state of things under which the facts in issue occurred, or afford an opportunity for the occurrence or transaction in issue. The facts covered under Section 7 are not facts directly in issue. Instead, they are facts that are connected to the facts in issue and help to explain how, why, or under what circumstances the facts in issue occurred. Okay. These facts are admissible because of their close connection to the facts in issue. Although they do not directly prove the offence, they are capable of indirectly proving or disproving the facts in issue. Okay, and then evidence of opportunity under Section 7 suggests that the act was most probably committed by a person who had the chance to do it. A person without such opportunity would have had to take extraordinary steps to commit the act. Evidence of opportunity, or in another word is the requirement of corroboration, must be supported by the surrounding circumstances. These circumstances must reasonably support the inference that the opportunity was likely to be taken. There must be a logical and evidential connection between the facts relied upon. Furthermore, evidence under Section 7 must be probative in nature. It must have sufficient strength and value in proving or disproving the fact in issue. Such evidence is often circumstantial, allowing the court to draw reasonable inference from conduct of physical traces. The opportunity relied upon must be a real opportunity and not merely a theoretical one. It must demonstrate that the incident was not a coincidence. Finally, mere suspicion is insufficient. Suspicion is based on conjecture or gut feeling without concrete supporting facts and does not amount to corroboration. For example, a police officer merely suspecting an individual near a store at night does not amount to proof. Without supporting evidence, such suspicion cannot satisfy the evidential requirement to prove the commission of the offence.
Now, moving on to the legal principle, which we will discuss on Section 7, particularly on Illustration C. In Section 7 of the Evidence Act of 1950, it states that facts are relevant if they show the occasion, cause or effect, opportunity, or state of things under which the act happens. Particularly touching on Illustration C, where the victim's health and habits known to the accused are relevant as they show opportunity. So these facts connects the circumstances leading to the event and help establish motive or opportunity. So starting with Section 7, to determine whether opportunity forms part of the surrounding circumstances under Section 7, we refer to the case of PP against Shahrul bin Razali, where the Court of Appeal referred to Section 7 of the Act and held that in establishing a person's intention, the court must look at the circumstances in which the act was done. In determining whether the evidence is admissible, the court will first consider the relevancy of the evidence. In PP against Sher Chinhua 1998, although the evidence of cigarettes were not part of the charge and argued to be prejudicial to the accused, the court held that it was still admitted as evidence, as the main consideration being relevancy of the evidence. However, referring to Section 136, subsection 1 of the Evidence Act, it reinforced this by requiring the court to admit evidence only if it thinks the fact, if proved, would be relevant, which can be referred in the case of PP against Ahmad Ibrahim, number 3, 1999. Moving to Illustration C, where it stated that the question is whether A poisoned B, and the states of B's health before the symptoms ascribed to poison and habits of B known to A, which afforded an opportunity for the administration of poison, are relevant facts. So in Illustration C, the victim, which is A, health condition before symptoms are relevant because it helps establish whether poisoning occurred. The victim's habit was known to accused, which is B, are relevant because they may have created an opportunity for administering poison. These facts may not directly prove guilt of the accused, but provide contextual evidence that supports the inquiry for the intention. So in Malaysia, it is clear that such facts must be corroborated with other evidence, which is this case medical reports, forensic findings. This can be seen in the case of Aziz bin Muhammad bin against Public Prosecutor 1996 and R.M. Malkali against State of Mara Maharashtra, 1973.
Hi, my name is SYAHIRAH and I am going to explain for the case of Aziz bin Muhammadin against BP. In the landscape of Malaysian evidence law, the case of Aziz bin Muhammadin against BP stands as a minor authority on the evidentiary value of opportunity under Section 7 of the Evidence Act 1950. So the case clarifies that while physical presence or opportunity may be relevant to the occurrence of a crime, it does not inherently satisfy the legal requirements for corroboration in criminal trials where the complainant's credibility is at stake. So the appellant was convicted under Section 367 for raping a minor based on evidence that he stayed overnight with the victim. The court held this only showed opportunity, not guilt, and without incriminating corroboration, the conviction was set aside, confirming that Section 7 relevancy alone is insufficient in sexual offence cases. So the issue before this case was whether the mere opportunity to commit an offence is relevant under Section 7 and can amount to corroboration. So the High Court considered whether being in a position to commit a crime is sufficient to support a conviction in sexual offence cases. So for the rationale stated that, the court held that evidence of opportunity is neutral in nature and, although relevant under Section 7 of the Evidence Act 1950, it does not amount to corroboration unless supported by independent evidence implicating the accused. So corroboration requires independent evidence implicating the accused. Mere opportunity is insufficient as per the case of Rosle against Whips. So in addition, opportunity is also corroborative only when supported by incriminating circumstances and not equally consistent with innocence. So, the High Court quashed the conviction for several primary reasons. Firstly, the mere opportunity established by the prosecution lacked the necessary incriminating links to the appellant. Secondly, the medical experts gave conflicting reports regarding the age of injuries, failing to prove that the rape occurred on the specific date alleged. This created a gap that the opportunity evidence could not fill. So, finally, the appellant's caution statement was ruled involuntary because it was induced by the father's advice in the presence of police officers. So, Augustine Paul J.C. ruled that even if the father was not the police officer, he was a person in authority in that context, making the statement involuntary and inadmissible. So therefore, as a conclusion, this case is a landmark for its strict adherence to the rule of practice in sexual offences. It reinforces the principle that while Section 7 makes opportunity a relevant fact, it remains as a weak form of evidence that requires external support to reach the standard of proof beyond reasonable doubt. It ensures that the warning danger is not merely a formality but a substantive requirement for a safe conviction.
Moving on to the core of the judgment, we will examine the four primary reasons why the prosecution case collapsed. These points illustrate the gap between mere suppression and actual legal proof. So, the first one is the prosecution relied heavily on the exclusive opportunity doctrine, arguing that since the home was secured, only the occupant could have committed crime. However, the court ruled that simply being the last person seen with a victim is not enough for a conviction. There must be a substantive nexus or something more to link to the accused to the act. Without this link, the prosecution theory remained an assumption, not a legal proof. Second, we must look at the nature of the circumstantial evidence. The law is clear. Evidence must be based on established facts, not hypothesis or suspicion. The court warned that for the circumstantial evidence to be considered, the finest evidence, it must lead to a single compelling conclusion of guilt. Here, the prosecution relied on the suspicion, which failed to meet the high legal standard required in criminal trial. The third one is, and perhaps most critical, is the failure was the inability to establish the precise time of the death. There was a complete lack of scientific or medical evidence to prove that the disease passed away within the time frame alleged in the charge. Because the timeline was never verified, the last seen theory effectively collapsed, a point that was later strongly upheld by the Court of Appeal. Finally, the court noted significant deviation in the investigation. The investigation officer was described as negligent for failing to produce a key witness, the maid, Ika. Despite knowing she was in Sarawak, this missing testimony combined with the lack of a clear timeline allowed for the multiple alternative interpretation of the fire. Ultimately, this gap invalidated the indictment and led to the acquittal of the accused. Now that we covered the specific failure of the investigation, let's look at the legal principle that the Court of Appeal used to justify the acquittal. The court relied heavily on the established legal authority to distinguish between could have and did. The Court of Appeal rejected the prosecution argument as misguided by applying the Saka law of evidence. The core lesson here is the distinction between having the opportunity to commit a crime and the actual preparation of that crime. As the esteemed author of Saka advised, a judge must be extremely cautious. While every crime needs an opportunity to happen, simply having the potential to cause harm does not bridge the legal gap to guilt. In other words, just because the respondent were in the house does mean they commit the act. To reinforce this, the court cited the precedent case of Aziz bin Muhammadin against public prosecutor. This case established that mere opportunity has zero evidential value unless it is corroborated by other facts. For an opportunity to be legally significant, the prosecution must show evidence that it was likely that the opportunity was exploited. In the Samirah case, the fact that they lived together only created suspicion. However, the court firmly stated that suspicion is not evidence and it can be never equated with proof beyond a reasonable doubt. To conclude my analysis, let's look at why this case is a landmark for modern Malaysian law. This judgment does not just apply to one case, it sets high standard for how all future criminal cases must be handled. The Court of Appeal made it clear, to establish a prima facie case, the prosecution must provide cogent evidence so strong that it would justify a conviction if the defense said nothing at all. It reaffirmed that the burden of proof rests entirely on the prosecution. They must prove every single element, from the exact time of death to identity of the culprit. The law does not allow them to fill gaps in their story with speculation or the mere opportunity of living in the same house. The second one, the ruling provides much needed clarity on the last scene together, doctrine and the role of forensic. The court established that being the last person with the disease does not create an automatic presumption of guilt, especially when there is evidence of positive relationship and negate a motive. Furthermore, the court set a very high bar for forensic integrity. It prioritized standardized, rigorous scientific analysis, overflowed and non-standardized evidence. Most importantly, it confirmed that the appellate court must intervene if a trial judge failed to properly appreciate the evidence. This preserves the integrity of our entire criminal justice system by ensuring that no conviction is based on weak sign or lack of evidence.
Assalamualaikum warahmatullahi wabarakatuh. My name is SYIFAA AMALIN Binti Muhammad Azlan, and now it is my turn to discuss on the comparison between mere suspicion and probative value and how it relates to Section 7, particularly Illustration C of the Evidence Act. Foremost, I would like to point out that the illustration C from the provision which specifically illustrate the concept of opportunity of occurrence. In this illustration, the issue is whether A had poisoned B. The relevant facts includes the B's state of health and habits are known to A, which afforded A the opportunity to administer poison. Therefore, two situations arises, which is the opportunity of occurrences and the defense of alibi. Both are relevant and admissible to be tendered. However, in making those inferences, the court primarily evaluates the probative value of such evidence and determined whether it amounts to a mere suspicion. The law is well settled that a mere suspicion is insufficient. This position was clearly illustrated in Aziz Muhammadin against PP, in that case, the accused and an underage girl were proven to have spent the night together. The court held that this fact is merely showed opportunity and raised only a mere suspicion, as there was no corroborative evidence that rape had occurred. Accordingly, mere opportunity alone without further evidence was insufficient to establish the offence. While in the civil context, in the case of Ding Ming Ming against Lim Sujin and another, a defamation case, the defendants relied on their belief and suspicion that the plaintiff was unlicensed. The court held that a mere belief or suspicion without proof was insufficient to discharge the burden of proof. This further reinforced the principle that suspicion must be supported by a clear and convincing evidence. A similar approach was adopted in the recent case of Komati Thamaraj against Thamaraj Pakirisamy, where this is a case from 2026, a recent one, where the Court of Appeal held that the fraud inferred from the circumstantial evidence must be corroborated and cannot be based solely on suspicion, which strengthened more on our argument and our discussion on this matter that a mere suspicion must be corroborated. In contrast, a probative evidence is an evidence that has the ability to make a fact in issue more or less probable. Evidence with high probative value is both relevant and carries significant weight to the fact in issue. Referring back to the illustration C, where the A's knowledge of B's habit and health condition creates a realistic opportunity for A to poison B. Such evidence can have a high probative value and carries a significant weight. The process of probative value can also be seen in the context of the defense of alibi. In PP against Lim Chen Len, the accused raised an alibi supported by 4 witnesses. Although the appeal succeeded on the procedural grounds, the case illustrates that a properly supported alibi carries a high probative value when corroborated with a credible evidence. Conversely, in the case of PP against Fong Kim Ho, the accused raised an uncorroborated alibi. The prosecution, however, relied on eyewitnesses, testimonies, and CCTV footage. The court held that the alibi was a bare denial, while the prosecution's evidence had an overwhelming probative value. In the case of in addition to that, the alibi which is a bare denial, had a low probative value. Therefore, as a conclusion, we can see the stark difference between the mere suspicion and probative evidence, whereby the former is more on a belief or inference that is drawn without sufficient supporting evidence. By the illustration C, it can be said that a mere knowledge of B's habit creates a mere suspicion that A might have caused B's poison. Therefore, a mere suspicion is not enough and must be corroborated. Without any corroboration, it stands as a weak evidence and cannot be tendered. While the latter is more on the evidence that is meaningfully prove or disapprove a fact in issue. Back to the illustration, the said opportunity evidence can be linked to A, can be linking A to the poisoning, and probative evidence can stand alone by itself and normally does not need any corroboration. However, it can be said that if there is any additional evidence to that specific conclusive evidence, it might have created a high probative value of that evidence, and such has a high standing and weight to the fact in issue. That is all for me. Thank you.
Today, I will critically analyse the rule that mere opportunity without more cannot amount to corroboration in Malaysian evidence law. According to Section 7 of the Evidence Act, makes opportunity a relevant fact because it forms part of the surrounding circumstances of the offence, but relevance is not the same as reliability. Opportunity on its own does not show that the accused probably committed the crime. It only shows that they could have done so. Courts held that the opportunity must be backed supplementary or corroborative evidence before it has real probative value. In Aziz bin Muhammad Din against DPP, the High Court found that there's a bare opportunity, uncorroborated, to be set aside the conviction and to acquit the accused. Same strict approach is taken in PP against SYAHIRAH, Nur Hafiz Hanapi, and Muhammad Azmi bin Yasri, where judges affirm that mere opportunity cannot alone corroborate the complainant or to prove guilt beyond reasonable doubt. Therefore, courts also accept the opportunity carries weight when combined with other incriminating circumstances. In Ahmad Najib bin Aris against PP, the accused's opportunity was reinforced by him being seen with the disease at the several locations, creating a coherent chain of facts pointing to guilt. So the opportunity plus surrounding circumstances could meet the beyond reasonable doubt standard. One academic commentary supports by a University of Malaya professor this cautious approach in drawing on Baldwin and making to argue that similar fact or circumstantial evidence should be admitted only when its probative value outweighs its prejudicial effect, not simply because it falls into category of opportunity. Malaysian courts echo this, stressing that what ultimately matters is that cogency and reliability of the evidence. Malaysian law adopts a consciously strict stance, which the opportunity is relevant but never sufficient on its own, because courts insist on corroboration and strong probative force to safeguard the presumption of innocence, avoid conviction based on mere suspicion, and maintain the rule that an accused is innocent until proven guilty beyond reasonable doubt.
As for the conclusion, relevancy is fundamental to the admissibility of evidence under the Evidence Act 1950. Section 7 provides that the facts are relevant if they show the occasion, cause, or effect of the facts in issue, constitute the state of things under which the facts occurred, or afford an opportunity for their occurrence. Facts under Section 7 are not directly in issue, but they are admissible due to their close connection to the facts in issue. Illustration C demonstrates that knowledge of a victim's health and habits may afford an opportunity to commit an offence, such as poisoning. However, this only provides context and does not directly prove guilt. Judicial decisions, including the case of Aziz bin Muhammad Din against PP and also PP against Samira binti Muzaffar, establish that mere opportunity is insufficient to sustain a conviction. Opportunity only gains probative value when supported by corroborative circumstances such as suspicious conduct, exclusive access, and also forensic evidence. In conclusion, while opportunity is relevant under Section 7, it is never decisive of guilt and without corroboration remains mere suspicion. Thank you.